The Delhi High Court on Wednesday declined the union government's plea to separately execute the death row convicts in the December 16, 2012 Nirbhaya gang rape and murder case. It also declined to set aside the trial court order, which had deferred the hanging of the convicts till further orders. It said the convicts cannot be hanged separately since they were convicted for the same crime. Justice Suresh Kait, however, gave convicts Mukesh Kumar Singh 32, Pawan Kumar Gupta 25, Vinay Kumar Sharma 26, and Akshay Kumar 31 7 days to exhaust all their available legal remedies. After this, the authorities would act as per rules, the judge said. The centre and the Delhi government had challenged the trial court's January 31 order staying till further orders the execution of all the convicts. On December 16, 2012, Nirbhaya, a paramedical student, was gang-raped and brutally assaulted by 6 men in a private bus and thrown out of the moving vehicle along with her male friend. The victims later died of their injuries. The 4 convicts have since been sentenced to death by a local court. The order has been upheld by the High Court and the Supreme Court. Except Pawan, all convicts have exhausted their legal remedy available to file a curative petition before the Supreme Court. The president has also rejected the mercy pleas of Mukesh and Vinay. A juvenile convict in the case has been released from a reformation home after serving a 3-year term. One of the accused in the case, Ram Singh, died in the Tihar jail. Senior politician and People's Conference Chairman Sajjad Lone and PDP leader Waheed Parra, close aide of detained former Chief Minister Mehbooba Mufti, were released from preventive detention here on Wednesday, officials said. After the release of Lone and Parra, 13 political leaders now remain detained at the MLA hostel here, which has been temporarily converted into a subsidiary jail. Mr. Lone and Mr. Parra walked free after being in preventive detention for over 180 days. The Jammu and Kashmir administration had on Tuesday released 2 leaders, former PDP MLA from Vachi in South Kashmir Ejaz Ahmad Mir and trade leader Shakil Ahmed Kaladar, who is former president of the Federation Chamber of Industries, Kashmir. Since Sunday, a total of 8 leaders have been released from preventive custody. These leaders were part of preventive detention of mainstream politicians, activists and trade leaders carried out after August 5 last year when the centre withdrew the special status of the erstwhile state of Jammu and Kashmir and bifurcated it into union territories, Ladakh, and Jammu and Kashmir. Among the prominent leaders who are still under detention are NC leaders Farooq Abdullah and Omar Abdullah and PDP chief Mehbooba Mufti. While Farooq Abdullah has been kept at his Gupkar house, his son and NC Vice President Omar Abdullah has been detained at Hari Nivas. PDP chief Mehbooba Mufti, who was initially lodged at Chezmashahi Huts, has been shifted to a government building in the heart of Srinagar. The senior Abdullah was slapped with the stringent Public Safety Act on September 17, which was further renewed for a period of 3 months on December 16. A 9-judge bench led by Chief Justice of India (CJI) S.A. Bobde will on Thursday hear detailed arguments on whether the Supreme Court can refer questions of law to a larger bench while hearing a plea to review its earlier judgment. This development follows renowned jurist and senior advocate Fali Nariman's objection on Monday to the manner in which the court turned a review of the Sabarimala case into an opportunity to examine larger issues concerning the essential religious practices of various faiths, including Islam and Zoroastrianism. And Chief Justice Bobde acknowledged that day that Mr. Nariman had a formidable point there. But senior advocate K. Parasaran countered Mr. Nariman, saying the Sabarimala case had its genesis in public interest petitions. The case was not an in personam affecting a specific person litigation. In a case emanating from a PIL, there was no restraint on a constitutional court in extending the scope or questions to be examined, he argued. Also read, Theological Thicket, on SC's hearing in Sabarimala temple case. The review of the case by a 5-judge bench led by then CJI Ranjan Gogoi took a curious turn on November 14 last. It sidestepped the task of reviewing the September 2018 judgment, which declared the prohibition of the entry of women of menstruating age into the Sabarimala temple as discriminatory. Instead, the bench referred 7 questions, including whether essential religious practices should be afforded constitutional protection under Article 26, freedom to manage religious affairs, to a larger bench. Further, the review bench tagged other pending cases on the prohibition of Muslim women from entering mosques, female genital mutilation among the Davudi Boris and the ban on Parsi women who married interfaith from entering the fire temple to the reference. Listen, how the Sabarimala case triggered larger, complicated questions on religious practice. Chief Justice Bobde, when he succeeded Justice Gogoi, promptly set up the 9-judge bench to decide this reference. On Monday, Mr. Nariman contended that the Gogoi bench had no business to either drag other cases into the reference nor frame such larger issues when its sole mandate was to simply review the Sabarimala verdict. He said he could cite at least 6 judgments of the court holding that a bench sitting in review cannot frame new issues and refer them to larger bench. Review jurisdiction is rare and limited. The task of a review bench is only to ascertain there is no apparent error or gross miscarriage of justice in the original judgment.